Hi, everyone. Welcome to our Facebook Live broadcast. I'm Steve Altition, Director of Client Partnerships here at Pacific Legal. And today we are with Attorney Joseph Willmore. We're going to talk about the important differences between California and Oregon laws. So, Joseph, how are you doing today?
Yes, good morning, Steve. I'm doing great. How are you?
I'm doing well. Sun's out, can't complain. So, let's before we start, just tell us a little bit about yourself.
All right, Steve. So I'm based in San Diego. We service all of Southern California with regard to family law issues. Of course, as you know, the bread and butter of that is divorce, but it encompasses every aspect of the familial life. That, of course, can include non-married people with regard to child support and child custody issues. Restraining orders, prenups, postnups, post-judgments, divorce issues, post-divorce support modifications, judgment enforcements when people don't do what they're supposed to do, and contempt as well when you want to have that overlap into criminal when people don't do what they're supposed to do.
That's the full meal deal.
Yeah.
I like that. How long have you been doing it?
I have been a divorce attorney for a little over 10 years now. In California, we have essentially levels of attorneys, so to speak. So I'm a certified family law specialist. So that means I am certified by the state bar as a specialist in the area.
I love it. Well, I would say you look too young to have been doing it for 10 years, but everybody looks too young to be.
So, especially in California, you don't know what's real, do you?
That's right. Well, this is actually perfect because, our topic today, and I really wanted to get into this because, we had a family law firm. A lot of times we get calls from people who are thinking about they need to get a divorce, but maybe it needs to be in California, or maybe they're thinking of moving to California, or their spouse is in California, just all kinds of different reasons. And, I know that a lot of the rules and the laws are similar, but I imagine there are going to be some quite different rules that, could potentially have a major impact on the way a divorce is handled in California. So, let's kind of start at the beginning with filing. Are there any jurisdictional or residency requirements that people should be aware of?
Yes, Steve, there are a number, and California actually has one of the easiest loopholes if you want to have jurisdiction here in California, and that's if in the way, or essentially our foot in the door here, if you I should say, don't meet the residency requirements, is to initially plead it as a legal separation. Which is the same process as a divorce, except you're not actually divorced, you're just legally separated, but you plead it in the alternative as a dissolution or divorce as well. And that's your sneaky way to get into California court, to have California have jurisdiction over your divorce. Now, typical residency rules, otherwise, if you don't do it in that fashion, is of course a minimum resident in California for at least 6 months, and in the county where you file for at least 3 months of living there.
Oh, okay. That's different a little. So if your marriage was in California and then you moved out, does that 6 months still apply?
Yes. So if you left California in a month, and then the month later you want to get divorced, California does still have jurisdiction.
Got it.
So even if you're not physically in California.
Yeah.
And I'll take it a step further, especially how transitory the world is now with, one spouse that may have moved away. So long as one person is living in the state, we still have jurisdiction, and we can just deal with all issues of the divorce.
I like that. But like you said, separations in California are handled a little bit differently, and that 6 month thing doesn't apply.
Correct.
So I take it you could file, get it started, and then just plead in the alternative, no, we're going to get divorced.
Correct. So actually, when we do this, we always plead it on the initial petition. So it's already indicated that in the alternative, we would go that route. But of course, we don't check any of the boxes for residency requirements simply because the parties haven't met that requirement. Now, the soonest you can even get divorced in California from the date you file it is 6 months. And by that time, you will meet the residency requirements as well. And the time period has already elapsed as well.
I get it. Oregon used to have that rule, but I think that one got abolished. So there's a difference. So let's look at fault. I know that California is a no-fault state.
Correct.
And most of the country, if not all now, I think is probably pretty close, if not no-fault state. What does that mean in California? Because I know in some states that means something a little different.
And it's interesting to me when I do deal with overlap issues in other states that do consider fault. Of course, infidelity, things of that nature have not been considered in California as fault-based since, I believe, don't give me the exact year, but I believe it's 1972. So the reason in California, at least at the time, was the court was spending too much time litigating who did what, who cheated on who, the evidence of that. And at the bottom line, the courts here said, well, does that really matter? And in the end, they said no. So at that point, fault-based infidelity, things of that nature are no longer a factor. Now, if you want to raise those issues, you can really only raise it with regard to a breach of fiduciary duty. So if you had, say, misappropriated marital money, say spent tens of thousands of dollars funding an affair, the spouse could certainly go after that in order to recoup the misappropriation of marital money.
That's a little bit.
But there's only very limited circumstances, of course, where you can argue that, or where that would be successful, or where you could bring up things that are fault-based of that nature.
Got it. Yeah, that's pretty close to Oregon. Oregon, I think, maybe is a little bit more open in terms of the ability to use bad acts, bad financial acts, as affecting a settlement, affecting a property distribution, that kind of stuff.
Yeah.
Now, I know one of the big differences, between California and Oregon property law is that Oregon is a common law property state. California is a community property state. I imagine that difference affects divorces and how divorces in California are determined, at least in terms of property.
Here's my take on that, actually, is I know community property sounds scary to a lot of people, and there's a lot of misunderstandings of that. So a lot of people will look at it as, well, gosh, if I get married to this person, half of everything I have is now theirs. And that is not true. So when, all the assets you had prior to getting married does remain your separate property. However, everything you acquired during the marriage is subject to community property law and would be divided. So one of the examples I use to try to bring clarity to this is if, say, husband has $100,000 in his retirement plan prior to getting married, gets married, and during the marriage, he accumulates another $100,000 in that retirement account. So now we have $200,000. The spouses separate, get a divorce. What is wife entitled to? Well, the community interest is only $100,000 because that was acquired during the marriage. Split that in half, wife's entitlement is $50,000. I think the common misconception that a lot of people think is that wife would have been entitled to $100,000 because that was one half of the total balance of that account.
Right.
I look at community property law as very predictable. So it's one of those those factors. So here in California, where it's actually, everybody thinks California is extremely litigious, which it is, but community property law really narrows down what you can fight about, because generally speaking, taking a divorce to trial on certain property issues simply does not make sense, because you can predict the results, and the judge is going to be bound by what the law says. You can always determine when assets were acquired. It's very easy to trace these things. So it's really only in those highly contentious matters where there's just no reasonableness or rationality that they try property issues of that nature.
Right. And that is a little different. Oregon has that equitable distribution where judges actually can go in, even though it's not common, and take separate property and give it to the other party.
Yeah.
Doesn't happen a lot, but it's that kind of fair versus equal.
And to me, honestly, I think that sounds scarier, because like I said, with community property law, it's just so predictable.
It absolutely is. So is the marital property split 50-50, or could it be split 70-30 in certain circumstances, or?
This is something that I tell clients, that if you want to truly tailor your divorce to get assets without, cutting everything in half, settlement is your best option to tailor that. Because ultimately, if we go to trial on a case, a judge will take things asset by asset. And that can result in something that the clients don't necessarily want. For example, if we have a house that was purchased during the marriage as purely community property, both husband and wife clearly have a 1/2 interest in it. If one of them wants to keep it, they really don't want to go to trial, because that judge is just going to order the house be sold and they split the proceeds. Yeah. So again, as far as tailoring settlement, you can always offset somebody's interest in something else by giving one of them more of this, and the other one gets less of something else. But that's really accomplished by negotiation and settlement, because again, trial judges don't care about that.
Yeah. It sounds like this is the way it is, and if you want it different, then you guys go out there and figure it out.
Correct.
I like that. Which kind of leads into, you had talked about you do prenuptial agreements. Everybody always wants to know, is a prenuptial agreement really enforceable? And so I know that in some states there are laws that really make it pretty darn enforceable, and in other states it's a little more open. What's California like?
So California, and it's explicit in California's Code of Civil Procedure, they really want to enforce written agreements. So from a general standpoint, and you'll want, of course, to have a good attorney to draft that prenup, because you also want to make sure that the clauses you have in there are enforceable and will be enforceable at the time of divorce. So the main reason for invalidating a prenup will be, well, there's a few reasons. I would say the number one reason is that it is not conscionable to enforce that prenup at the time that you're asking them to enforce it. So an example of this, and we need extreme examples because it's extreme situations when this really happens, is say a husband and wife gets married. In this case, there was a spousal support waiver, meaning neither of them could request spousal support at the time if they were to get divorced. And 20 years passes, and husband has a catastrophic injury and is paralyzed, can never work again. They get divorced. In a situation that extreme, a court is highly likely to say this clause in this prenup is extremely unconscionable because this man can no longer work. It would be impossible for him to support himself. So based on this unforeseen act, this unforeseen event, the court would likely strike that clause in that situation. Another example is lack of financial disclosures. So if you didn't make, so both husband and wife or I should really say husband, husband, and wife, wife, whatever the situation may be, if they don't disclose their financial situation, meaning break down all of their assets and debts when they're discussing and negotiating a prenup, that is also a strong reason to invalidate it, because of course the reason for that is the other person didn't know what they were contracting to, because they didn't have access to all that information.
That makes complete sense. That really does that too. What about property in, let's say, Oregon, as an example, that the couple owns, they're in California and they're having a divorce. How is that property treated? I know that Oregon has a rule that basically says if there's property in another state, we look at that state's kind of property rules to figure out what to do. How's California work?
We do not. So we apply our laws within the family code here, regardless of where the property is located. So here in San Diego, or most of Southern California for that matter, oftentimes we even have property issues that overlap Mexico, or I've dealt with issues in Europe as well. And all assets they have are considered marital property, regardless of where it is located. Now, issues of enforcement can arise, which we've dealt with on a number of cases previously. One in particular comes to mind, and it's a case with a lot of assets in Europe. And in this case, in order to secure, and rather I should say, these assets were not in my client's name as well. So in order to secure settlements, it was absolutely critical to make sure those assets were either jointly titled prior to agreeing and signing off on anything, and actually dividing assets here as well, just to make sure that we secured my client's interest in those assets. So again, we have jurisdiction as far as, of course, issuing a subpoena. In Europe, they're going to throw it away. But if we can at least secure those assets, we at least have our clients in a safe spot where we can say, all right, well, these marital assets are all safe. We can divide them, and the client will be able to move on.
I like that. I like that. Okay, let's move to support. Support is obviously a big deal, and we'll kind of just start real quickly. Child support in Oregon, we have a calculator, and you can deviate a little bit from it, but it really is all about the math, pretty much, when it comes at least to child support. And I know that child support can be really contentious. I'm paying too much, you're not paying enough, and but it kind of is what it is in Oregon. How does California deal with child support?
Well, child support numbers are shockingly extremely high here on average. So when I do look at figures that we calculate here in California compared to other states, I can say it's generally quite a bit higher. California bases that on cost of living standards. So again, when we talk about jurisdiction issues as well, it is something that courts can factor here if the child, say, moves away with one parent to another state, yet California still has jurisdiction over the matter. Of course, they consider factors such as that to why California support levels should or should not be enforced. But from a few things, you mentioned that Oregon, the judges can actually deviate from the formula that they calculate. Is that correct?
Yeah, a little bit.
Okay, so here in California, judges are prohibited in the family code from deviating from what is calculated. So what that leaves us as attorneys to do is argue what should and should not be considered income, what deductions may apply, and really nickel and diming the exact number for parenting time. Of course, it's always parties don't, when, say, for example, there's an equal timeshare between right. Mom and dad, and from the general public would say, well, if they have equal time, neither of them owes the other person support, child support. However, there's That's not how the law works here, of course. So if one parent, say, makes $10,000 a month, the other parent makes $20,000 a month, they have an equal 50-50 timeshare. That parent that makes $20,000 a month is going to pay child support to the parent that makes $10,000 a month. The legislature states that that is fair because the child is entitled to the same lifestyle in both households. Really, the only way the courts, or rather, I should say, the circumstance where deviations from this guideline support figure can occur is in situations of extreme wealth. And of course, you can guess very few people qualify for this. There's maybe a few celebrities, maybe Elon Musk here, but I think he moved to Texas. So there's very few situations where the extreme wealth exception will apply to deviate from guideline child support.
Okay, spousal support. You know, all of us in the other states, that used to be the big thing we would notice about California divorces is these, spousal supports. I mean, that was front page news.
Mm-hmm.
And so I did look a little bit on California and how they kind of do spousal support, and it is a little different in Oregon. So can you kind of go through the different kinds of spousal support that people can get and how it's measured and how long it lasts?
Okay, so you said it correctly that spousal support figures, shockingly, are also very high here. One of the big differences, however, between child support and spousal support is where judges do have tremendous latitude in their discretion on how they want to order it. And I can tell you, I've, of course, been before every judge, every family law judge here in San Diego County, a lot of judges throughout all of Southern California, for that matter. And we as attorneys learn which judges really, their biases that they have, judges that are always going to order higher levels of support, and those judges who, if you're representing the lower earning party, they're not going to be very generous. So it's really a matter of phrasing these appropriately, learning the judges, learning what they really factor in order to tailor our cases and our clients in order to showcase the various need bases, or if you're representing the higher earner, why that other person has an earning ability, maybe not living up to it, and so forth. As far as length of spousal support paid, any marriage in California greater than 10 years or greater is considered a long-term marriage. And in the family code, there is no set end dates for spousal support. Now, as general public policy, it is generally looked at as a reasonable time period for a person to, say, become self-sufficient and self-supporting. Is generally looked at as half the length of marriage. But again, for a marriage 10 years or greater, that presumption doesn't exist. So, now for a marriage less than 10 years, the family code prohibits a judge from ordering spousal support beyond half the length of marriage.
It's then incumbent on the person paying, I take it, to go back into court and showing that this has occurred. Is there a presumption of any sort when that happens? I mean, is it like more probable? Do you have to show a change of circumstances, or is it more like, okay, it's been this many years, let's not favor either side and look at the numbers now?
Okay, so I'll give a few examples here. So if we have a marriage that's, say, for example, 5 years in length, and both spouses are in their 30s, but we had a wife that was a stay-at-home mom during that time. Husband had the ability, of course, to work full-time, further his career, and so forth. It's a good chance that we'd call it interim support, so temporary support, would be very high. So the judges can still use the same calculation that they use to calculate spousal support to calculate child support, and it'll show a guideline number, which is going to be quite high. In this situation, it's highly likely a lot of judges would order that guideline high temporary support figure. Now, for a marriage of just 5 years, the stay-at-home mom in this situation is only going to be looking at 2.5 years of spousal support. So, of course, it's going to be absolutely necessary for her to obtain some job skills or reintegrate into the job market at that point. In a situation like this, it's unlikely that they would have to come back to court if they both have at all even reasonably sophisticated attorneys. They should be able to settle that. However, even if that case were to go to trial, it's likely that husband in that situation would pay high support for 2.5 years. But at the time of trial on that matter, it's highly likely that that judge will just order this as spousal support. It's going to elapse this entire 2.5 year period,
Right.
and it automatically terminates at the 2.5 year mark. Yeah, I can give an example on the other end. Whereas if we have, say, a 30-year marriage and parties, husband and wife, are getting divorced in their 50s, we have a much different situation here. So say we have a similar example. We had a stay-at-home mom who raised children. Of course, now they are, say, adult aged at this point. Husband worked that entire 30-year marriage, supported the family. Husband's not in a great position when it comes to support here. Now, we have ways of ensuring or trying to get a person to become self-sufficient, and in California we call those Gavron warnings, and that's to where the party who would be receiving spousal support is ordered by the court, like, this is your notice that you need to take steps to become self-sufficient, self-supporting within a reasonable period of time. Again, reasonable, we're going to say half the length of marriage, so 15 years. So say the wife in this situation is 50 years old. I believe a Gavron warning in most situations would occur in that situation, because we're looking at least 15 years of still working life left in her. There's no imputation of income for purposes of calculating spousal support until a person is over 65. So we're looking at that 15-year period of wife taking steps to become self-supporting. Now, if I were advising husband in this case, the payor of spousal support, I would say, well, we're going to ultimately have support orders in place. It's highly likely the court, so say we do have a Gavron warning issued for wife, it's really upon him roughly to look at every 5-year mark as, well, I'm going to have to file a post-judgment support modification because 5 years has elapsed. The wife in that situation should have taken reasonable steps. It's hopeful that she would have. And, at that point, if we look at the evidence and she has not taken those steps, the judge can also consider that as a means of, well, you didn't do what you were supposed to do, so we're not going to keep support this high. We're going to start with downward modifications. Wow. Now, termination of spousal support in those situations, I would go so far to say slim to none. I would say the absolute soonest a husband in this situation for a 30-year marriage would even be able to enjoy the possibility of that is after 15 years has passed, just given how long that marriage is.
Yes. Wow. One thing, and I know we're unbelievable again, this is so informative and it goes so fast. So we're almost done. But I want to talk just for a second about taxes on support. It's confusing, and it was made a little more confusing because, what was it, 2016, 2019, whatever it was, when they changed the federal rule on spouse support. But what is the rule in California, and really specifically the state rule when it comes to, let's say, spouse support, and who pays and who gets it as a deduction, if anybody?
So as you stated, the federal tax laws apply here, and previously, prior to the change in the tax code, where the payor of spousal support was able to claim it as a deduction, and of course it was taxable to the recipient spouse. That really made it advantageous for us previously to negotiate equalizing payments. So a one-time settlement payment to who would have been the recipient spouse in lieu of them agreeing to waive spousal support.
Right.
So we don't really have that negotiating chip anymore, as far as here take some money and go away, which would be a lesser amount than what you may have received in spousal support, but it's also a lump sum of cash versus payments over several years that you may or may not receive based on if you have that assurance of payment. So that certainly affected things to a degree. Obviously, when we calculate, again, guideline numbers, so if we turn to this calculator and run support numbers, since that payor is paying support, support numbers did go down. The court certainly does factor that in, since they no longer can deduct that, since they're paying the full tax on all of that. Now, I guess you and me aren't CPAs, but we can assume that maybe the IRS wanted to tax the higher earner because they were in a higher tax bracket as well. But, of course, as practitioners, we're the ones that are left to deal with the consequences and how it affects our clients. And, when taking steps to at least try to negotiate settlements, what advantages or disadvantages that offers our clients.
Yeah. And does that apply to state tax?
Well, state tax, they don't deduct support on state taxes either.
Got it.
For support, at least. Right.
So we are past our 30 minutes, but is there something we missed? Is there something that, kind of a final thing you would want to say to someone if they're contemplating either getting the divorce in their state or in California, that we just didn't touch? Or did we catch most of the big stuff?
I think we caught a lot of the big things. I think it's important for people, especially when spouses maybe reside in two different states, that they consult with people in both states. I think that's absolutely helpful for people. I think taking some of the principles that we talked about today certainly should at least help people make decisions even without talking to people, as far as which side of the spectrum they may fall on.
Exactly. And on that note, would you like to tell people how they could contact you?
Absolutely. Always welcome to give our office a call. Our phone number is 619-550-6738, or visit us on our website, willmorelawfirm.com.
Love it. And so, Joseph, thank you so much. You bring knowledge, experience, you talk about stuff that's complex and difficult, and you make it sound understandable, even to someone like me. And that's very much appreciated. So thank you for joining us today.
All right, Steve, thank you for having me.
Oh, I love it. And you know what? I want to do it again. I want to get into retirements and how they're affected in divorce. Nothing better than a good talk about a quadro.
I'm sure people will be delighted to hear that one, right?
So everyone else, also, thank you for joining us. Until next time, stay safe, stay happy, and be well.